Hello there, I am DJ Lady Loy on Gold Standard Radio. I'm also on Lovers Rock Radio. This is just to give you a little background. Basically, I am a DJ. I'm on Saturdays 7 till 9 on Gold Standard Radio and Fridays 7 till 9 on Lovers Rock Radio. What I've always done, I've always had an interest in immigration, so I am using the platform of Gold Standard Radio to talk about some of the immigration issues because it's an international radio station and we could have DJs or artists with immigration queries. So I'm going to dedicate this channel to subjects like that may affect or impact DJs or international artists. So I'm not quite sure how much I'll get into this, but I'm going to read my notes so that you understand. But basically, the Home Office have come out with new rulings on suitability. And well, there are three things that govern whether or not you're going to be successful in your application. The first one is eligibility, and that has to do with filling out the form correctly. So you have to make sure that that is on point. The second thing is suitability, which will be the subject of this video, and that's about your character. And the third thing is substance, the actual documents and the supporting information that sways the Home Office as to whether or not you're going to get your leave to remain. So, character. Now, there are some obvious reasons why you will not be considered of good character if you have a criminal record. Now, they do say if you've been in prison for 12 months, that's the reason, but more recently, they are closing the gap. Any kind of criminal activity could render you as an unsuitable person. Why? Because a person of good character is meant to have a clean record. Any kind of deception, whether it's in your current application or previous applications, is not going to fare well. Any kind of, what else is there? Oh, if you've had, which is quite obvious, if you've got a deportation order out against you, you're not going to be able to apply for your leave to remain. Using false documentation or ID, even if it wasn't your fault. You know, we've had a lot of situations where people have come from abroad, they've paid somebody to do their paperwork, and the people have used false ID and identification. You haven't realised that to be the case. You are now a victim of that, and it's going to mess up your whole application. So whether or not it's your fault, you always have to take legal advice. There's always loopholes, there's always exceptions to the rules, and it's always best to get legal advice. I'm only OISC qualified up to level 2, so I can't give you advice, so no point asking me any questions. Anyway, let me just go quickly through this to make sure that I am covering. The Home Office may refuse your application if the offence is less serious but considered not in the public interest, or if there's a pattern of minor offences. So even if you haven't done a major offence that's put you in prison, if you've got a pattern of maybe shoplifting or other kind of small offences, it could still go against you because you're not considered a credible citizen. Credible citizen doesn't break the law, according to them. Nobody's perfect, but there are certain things that you just don't do. Fraud, debt, those kind of things. They do not consider you of good character if you've accumulated debt. Are you an example of a good citizen? No criminal records, no debt, you've got adequate income, sustainability, you can look after yourself without no recourse to public funds, you're secure, you're stable. You've got a tenancy agreement, home, those kind of things, because all of these things tell the Home Office that you're credible. because to get a tenancy agreement, technically, you're of good standing. You're legally in the country and you have a job, those kind of things. Have a bank account, and those kind of things tell the government that you are a legal individual. A lot of time decisions are at the discretion of the Home Office case holder. It could be your lucky day, but more than likely, even if you've returned to your home country on your own accord and at your own expense and waited more than 12 months to apply, you could still get refused. So some people have overstayed and then they've, or for whatever reason, they've paid to go back, they've decided to go back. It could still go against you unless you've got a really concrete reason as to why you overstayed. Then they can consider that. But you must need evidence. What else have I got here? And they waited, okay. The very act of overstaying could render you unreliable and untrustworthy unless you can prove unequivocally the reason you overstayed. And the Home Office finds your reason to be a valid one. That's what I said before. Even then, if your reason for overstaying was valid, but you did not notify the Home Office and you needed to overstay, and you're still frustrating immigration rules and therefore breach them, it could still render you an unsuitable applicant. The thing is that people don't realise if you overstay for a valid reason, you must let the Home Office know, because that shows that you're honest. It shows that you're credible. You may be thinking, I'm not going to let them know because they're going to send me back and my mum's died or this has happened. I've got to stay. I need to overstay. But you're not doing yourself any favours, because once you overstay and you do not inform the Home Office and you do not let the Home Office know your latest situation, that goes against you as being a good character. A lot of times when we do things wrong is actually owning up to what we've done wrong, being responsible and accountable. That makes you of good character, because like I said, no one's perfect. But if you own up and you let them know your circumstances, your situation, I'm not saying it guarantees you to stay in the country, but you've got a better chance of being considered someone of integrity than if you don't. If you hide, you duck and dive. Like I said, refusal is at the Home Office's discretion. It's not an automatic refusal, but for peace of mind, I'm inclined to think it's best to think, oh, I'm not going to get it, than to think you are going to get it and then get disappointed. Let's see, there are some illegal residents who believe they are eligible to switch their visa status because they've lived in the country for say 25 years. Needless to say, the Home Office would treat such an application with scepticism. An illegal immigrant goes against the very essence of what they are about, which is to stamp out illegal immigration. Regardless of the reason you are illegal, if you have not kept the Home Office updated of your whereabouts, position and situation, they will not look on your case favourably. Like I said, it's always recommended to get legal advice in these situations, as there are always exceptions and there may be loopholes. Joshi Associates, I got some of the information from her. She's really, really good. And she gave the example of, imagine someone comes to the UK unlawfully and then they manage to obtain 2.5 years leave to remain as a spouse under exceptional circumstances on the 10-year route. So they're granted 2.5 years on a 10-year route, and then 6 months after granted the 2.5 year on the 10-year route, they then want to switch to a 5-year route because they are now lawful, which means they meet the financial requirement threshold of 29,000 annual earnings, blah, blah, blah. But what will matter in this situation is that their initial entry into the country was illegal. So even though they've done it and they've passed all the loopholes, now when it comes to finalising it, they'll go back to how you originally came into the country and you will not get through. So different lawyers have different interpretations. Find yourself a good lawyer, and that's all I've got time for now. Bye bye.